Hello, my name is Ollie Foy. I'm a barrister at Pump Court Chambers. This webinar is a brief introduction to a highway authority's statutory duty to maintain highways and the consequent claim which can be brought for breach of that duty. The relevant piece of legislation is the Highways Act 1980. The Highways Act 1980 is an act of Parliament which consolidates a series of enactments relating to highways. That consolidation included a private law remedy for damages arising from a failure to maintain the highway, and that had been introduced back in 1961. The purpose of the duty is to ensure that the highway can be used with safety by members of the public. The reason we needed a statutory duty was because common law did not permit the recovery of damages for breach of a duty which was interestingly founded in nuisance rather than negligence. The duty on highway authorities is found in section 41 of the Highways Act 1980. There is thus a statutory duty to maintain highways which are maintainable at public expense. As we will see in a moment, that is an absolute duty, and there's always been a due care defence of some kind available to the highway authority. Section 58 of the 1980 Act provides a statutory defence where, even though the highway is dangerous, the highway authority has taken all such care as is reasonable to secure that the highway is not dangerous. These are the two sections I will focus on. They effectively amount to a two-stage test for a claim. First, is the highway dangerous? Second, if so, has the highway authority nevertheless taken all reasonable steps to prevent the highway from becoming dangerous? The broad effect of section 41 is that a highway authority has a duty to maintain a highway where that highway is maintainable at public expense. This begs the questions, of course, what is a highway and what is a highway maintainable at public expense? Very briefly, a highway is a route over which the public at large can pass and repass as frequently as they wish without hindrance or charge. The definition of a highway therefore covers a range of examples. It may be an all-purpose highway, which allows motor vehicles, pedestrians, and cyclists. It may be a carriageway over which vehicles may pass. It may also be a footpath or a footway, which is adjacent to a road. A highway maintainable at public expense will be defined as such by statutes or by statutory adoption procedures. A local highway authority is obliged to maintain and make available an up-to-date list of the streets within its area which are publicly maintainable highways. Once those preliminary hurdles are passed, Lord Justice Steyn gives us a very helpful three-stage test, summarising what is needed for a successful claim. He says this: in order for a plaintiff, a claimant, to succeed against the highway authority in a claim for personal injury for failing to maintain or repair the highway, the plaintiff must prove that the highway was in such a condition that it was dangerous to traffic or pedestrians, in the sense that in the ordinary course of human affairs, danger may reasonably have been anticipated from its continued use by the public. The dangerous condition was created by the failure to maintain or repair the highway, and the injury or damage resulted from such a failure. If acting for the claimant, that three-stage test is a blueprint for your claim. A duty to maintain simply means a duty to repair and keep in repair. Lord Diplock has summarised the duty as being to ensure that the road was reasonably passable for ordinary traffic and that it was not in a physically dangerous condition. The duty upon highway authorities is absolute. It must satisfy this objective standard, and the authority must levy whatever rate is necessary for the purpose. If the condition of the highway falls short of the statutory standard, the highway authority is in breach of duty. It is no answer that it took all reasonable care or that its resources were insufficient. That does not mean that the highway has to be perfect or pristine. There will always be some weathering and wearing away of roads, pavements and paths, resulting in small divots, slopes or broken edges, which might provide some kind of risk to the unwary and lead to accidents. The highway authority is not automatically liable for these accidents. There must be something over and above the risk of injury from the minor blemishes and defects, which are habitually found on any road or pathway. The claimant has to show that the highway was dangerous, in the sense that danger could reasonably be anticipated from its use. Section 41(1)(a) is a relatively recent addition to the 1980 Act. It was introduced in response to the decision of the House of Lords in Goode and East Sussex County Council. The claimant in that case skidded on ice and was gravely injured. However, the claim was dismissed. Their lordships drew a distinction between keeping the highway in good repair and keeping it free of ice. The duty under Section 41 relates to the fabric of the highway, and the House was concerned that a duty to keep it free of ice would draw the duty far too wide. Section 41(1)(a) deals with this. It is a separate, standalone duty. It is not an absolute duty. The section requires the highway authorities to ensure, so far as is reasonably practicable, that safe passage along the highway is not endangered by snow and ice. What this really underlines is that the standard Section 41 duty does not extend to surface lying material, obstructions or spillages. There is no duty to remove transient materials such as moss. Only if the material in question has become part of the fabric of the highway, such as a concrete spillage, will it fall within the scope of the authority's duty. The duty does not extend to pure economic loss. That was made clear in Wentworth and Wiltshire, where the claimant, the owner of a dairy farm, attempted to sue the highway authority because the state of the highway was preventing the milk tanker from reaching the farm. The economic loss that was being claimed was not recoverable. Section 41 is, of course, a statutory duty. This is not a negligence claim. It is a claim for breach of statutory duty. As you would expect, the claimant brings the claim and the claimant must prove the claim. That is done by proving, on the balance of probabilities, the three hurdles set out by Lord Justice Steyn. Before we get to that point, however, The burden of proof rests on the highway authority to show that it is not responsible for the maintenance of a publicly maintainable highway, the highway in question. And the highway authority will not be responsible if they cannot prove, or the highway authority will be responsible, forgive me, if they cannot prove that someone else is responsible. Determining what amounts to a danger is a very fact-specific exercise. The location of the hazard will almost always be significant. Different considerations will apply to the remote countryside when compared with a bustling city. A danger in Mile End might not be a danger in Bodmin Moor. The purpose of the highway will also be significant. As was said in one case, a stretch of uneven paving outside a factory probably would not be a danger for traffic, but a similar stretch outside an old people's home and much used by the inmates to the knowledge of the highway authority might be. It is therefore a judgment call in each case. The Local Authorities Association publishes a code of good practice for highway maintenance. That code gives guidance as to the circumstances in which a particular defect is sufficiently hazardous to justify repair, having regard to its dimensions and location. His Honour Judge Likely's judgment in Nash and Hertfordshire serves as a reminder to ensure good quality photographs are taken of the alleged dangers. In this case, the judge could not understand why photographs were not taken with an object or measure to demonstrate depth, and this serves to underline that good quality photographs should be included, photographs which are accurate and photographs which will actually assist the court. Contributory negligence is a factor to bear in mind for Section 41 claims, of course. If you are for the claimant, you must remember to particularise all claimable losses, personal injury, special damages, and future losses. To mitigate the effect of allowing a private cause of action for breach of an absolute duty, the Act gives highway authorities what is known as a special statutory defence. The highway authority will have a defence if it has taken such care as in all the circumstances was reasonably required to secure that the part of the highway to which the action relates was not dangerous to traffic. Traffic includes foot traffic, of course, i.e. people walking as well as driving. The highway authority must take reasonable care. And what this means is that the authority cannot argue that it would have made no difference had reasonable care been taken. The court must, and I emphasize must, take into account the factors listed in Section 58, which I have summarized on the slide, but it's definitely worth going to the section itself and looking at them. Bearing these factors in mind, the highway authority will often argue that it applied a system of maintenance and inspection to bring itself within the statutory defence. Under Section 58, the burden flips to the highway authority. The test under this section is an objective test based upon risk. Budgetary constraints are not relevant. Section 58 was designed simply to afford a defence to a claim for damages brought against the highway authority, which was able to demonstrate that it had done all that was reasonably necessary to make the road safe for users. Not an authority which decided that it was preferable to allocate its resources in other directions because other needs were more pressing than doing what was reasonably required to make the roads safe. If the court determines that inspection periods were not frequent enough. For example, the Highway Authority cannot argue that more frequent inspections were unaffordable. There is a code of practice, well-maintained highways, which gives guidance to highway authorities as to the frequency of inspection for dangers and identifies categories of defect by seriousness and suggested urgency of repair. The code of practice is not determinative, either in respect of whether there's been a breach under Section 41 or whether there is a defence under Section 58, but it is evidence of good practice and it may be of assistance. It's not enough for a highway authority to say that it gave proper instructions. Those instructions must be carried out. If you're acting for the claimant, it is good practice to probe any training that was given and to probe the implementation of that training. In Crosby and Wakefield, the defence failed because the highway authority had failed to record any measurements it had purportedly taken during inspections. There was therefore no way of knowing whether its policy had been correctly applied or whether the authority should have known about any dangers. A mandatory consideration under Section 58, of course. In practical terms, what this case underlines is that there must be evidence that a well-intentioned policy has been complied with. I hope that is a useful introduction to highway claims. Thank you very much for listening.